value of 1989, my lord's order, the rationale was very simply this. Give a compensation which is capable of enabling me to buy something. That was one option. Second option was get, my lords, the persons who are encroachers to pay additional, my lords, for the fact that they have used the place for all this time. Third option is alternate land to be given to both of us by which the state gets the land. The state doesn't look at any of these in this perspective. And when it was question of compensation, just have a look at my lord's order, my lords, of March 25. Para 5 of my lord's order, my lords.
The first part is concerned, Mr. G. Krishna.
Yes.
Suppose the compensation assessed
Yes.
erroneously on a date of 89, instead of, let us say that you must be talking of it 25 to 26, one way. That can be solved by granting liberty, and when we can create a tribunal for that to determine your adequate.
I'll tell you what there are 3-4 problems in that, my lords. That's one approach I bowed on to that. But please see, my lords, we have been now agitating. We are owners from 68. Land hasn't come to us at all. From, my lords, the 80s, the encroachment start. The state, my lords, aids that encroachment by issuing a notification as though it's a slum in 92. Now we fight all through, my lords, succeed before the High Court to get it set aside. Thereafter, the state comes before the court. 25, 30 years have gone by, my lords. We don't have the benefit of the land. And today we don't get the benefit of the money also. And High Court, this was for the very reason where the state acting in this manner was because of, my lords, the involvement of a minister. The minister was implicated as a party. He has passed away today. But he was made a party.
Going into all these questions, Mr.
Therefore, my lords, correct.
Will complicate the issue.
There are 2 ways of approaching it. I understand. There are 2 ways of approaching it, my lords. Here and now, before my lords, there has to be a better look at, my lords, some date which
is recent. That you get, at least if not adequate, some compensation.
Correct.
With an open window to seek enhancement in accordance with law, we can direct the court of the district judge to entertain and to decide your compensation claim immediately. 1. 2. Assuming the cutoff date of 89 as of now, when you are supposed to get compensation in 26, you will be in any case entitled to interest.
No, my lords. In fact, what they have done is, this is some kind of an ad hoc arrangement they are making. They are saying 89, the value of the land is 400 rupees per square yard. I'll add 12% every year for it and makes it 2,500. It's extremely, my lords, preposterous. Today, the value of the land is 3 lakhs plus per square yard.
Today, Mr. Guru Krishna Kumar, neither you have land nor value,
exactly,
nor money.
That's correct.
Your land has been encroached upon.
Absolutely.
Absolutely. And do you think that in our system, anybody will be able to touch them?
No.
So your land has gone.
I understand. I quite see that.
Your land is deemed to have been donated. Let's be very practical.
No, I understand. I quite see that.
Whatever you are getting is only on account of judicial intervention.
Absolutely.
So you need to be very pragmatic and practical in your approach.
Yes.
So maybe there is that
one other factor, my lords, if my lords don't mind.
Look at the other aspect.
Yes.
State is not. It is not a case where eminent domain power, they need it for commercialized use.
It's not so.
They are also caught. They are
by their own making, my lords.
Whatever it is.
Their own making.
Who were there, how the law machinery failed, who were the persons behind it.
Correct.
These are the challenges in Bombay you face, in Delhi you face, now that you are facing in Hyderabad also.
Absolutely.
Maybe other cities also, country.
True.
Unfortunate situation where poor people, they don't have any shelter, they come to urban areas for livelihood, and then they start settling down somewhere. These are ground reality.
That's right.
Now, they also, it's a part of their social welfare obligation that they are doing.
Yes. In fact, my lords, it goes a little beyond social welfare obligation. They are trying to unscramble, my lords, a problem which they themselves created. Now, in the process of doing that, my lord's order, just have a look at that, my lords. My lords very clearly said, choose a cutoff date if you want to pay compensation, which is rational. The question is, what kind of date you have chosen? There are 2 approaches in my respectful submission, my lords. 1, let them, my lords, look at what we have filed as an affidavit. Come back to my lords on a better date. One possibility, and leaving open the question to be decided by a tribunal. That's one way of looking at it. Second, my lords, why is it that the state is not looking at alternate land for us, my lords? They have large pockets of land. They are auctioning all of them every now and then. These are commercial activities of the state. Now, that is an option which my lords had given, my lords. They are not even looking at that, my lords. I ask myself the question, why is it that the state doesn't look at that option? I'm saying only one thing, my lords. Let the state, my lords, respond to this affidavit of ours. There are 4 options given by the corporation itself. Why did they choose only this? Should they not look at something better? In fact, High Court said, all right, for all the mistakes that you have committed, you pay compensation. What fell from my lord, the Chief Justice? Their mistake. You pay compensation under the 2013 Act. There has to be some rationale, my lords. Just have a look at my lord's order, my lords. The previous order in March. 27.3.25, my lords. Para 5, my lord. Just have a look at it, my lords. Para 5.
Mr. Advocate, you are there. Dr. Menka, you are there.
My lord.
Some way out, you have to find out a reasonable way out. Telling them to have a compensation of 89 will be.
My lord, sir, that is the date on which the land grabbing cases were decided in their favor. And then that is 1989. Subsequent to that,
You couldn't remove the encroachments and could not hand over the.
they enter into a settlement in 1991 with the encroachers. 25 rupees, my lords. That is their settlement that they enter into. Now they are here, my lords, asking for something which will broadly reflect a market value, which is not possible, my lords. That part of town is a very expensive part of town. Now, my lords, we only go in and provide some sanitation facilities, which we have to whenever there's something which looks like a slum. That is all we did.
What rate you have offered to them?
My lords, 400, my lords. We have offered 400 per square yard, my lords, as on 15/9/1989 plus 12% interest. Plus 12% interest.
Which comes to a princely sum of almost 2,500 per square yard.
What is 1%?
But then you have to be vigilant about your land.
The state talking about vigilance, I'm so sorry. They encouraged the whole thing, my lords. They issued a slum notification. It has been set aside by the High Court, passing strictures against the state.
Slum
State has been singularly responsible for this, my
slum
lords,
is
for the
only
state of
for
affairs.
sanitation.
At
my
the
lords.
instance of
That
a
is what
minister.
we provide. Sanitation facilities.
Just have a look at para 5 of my lord's order, my lords. Just have a look at that for a minute, my lords. I'll just read that for a minute. My lord's approach is telling. The state has not even paid lip service to this approach, my lords. Please see para 5. It will be too harsh and unfair at this stage.
Para 5 of which state?
This is 27.3.25, last year's order, my lords. When my lords gave the broad indications of what possibly could be tried.
Date.
It is 27th of March, 25. Para 5, my lords.
Para 4 onwards, my lords. Like my friend will read para 4
I will.
onwards. Thank you. Thank you.
I'll read from 4, my lords. My friend wants me to read from 4. During the course of brief hearing, it clearly emerges that the subject land is now predominantly occupied by persons who are not the original slum dwellers, though some of the slum dwellers might still be living there. The nature of the structures now raised at the site belie the claim that such occupiers are persons belonging to marginalized sections of society, economically backward classes, or they are living below poverty line. In other words, these occupiers apparently have the capacity to bear the cost of acquiring a valid title, acquire the piece of land under their respective occupation. Now, 5. It will be too harsh and unfair at this stage to expect the society owner of the land to accept compensation that may be assessed under the 56 Act. On the other hand, if the society is granted a reasonable amount of compensation, considering the estimated market value of the land at a cutoff date, which can be fixed by the state as a policy measure, it will enable the members of the society to look for an alternate site for their social security. This is important, my lords. Now, please see, compensation amount payable can be recovered, etc. Now, please see para 8 also.
It can be recovered from the occupiers of
That's
the land.
correct. Yeah, that's correct.
For the reasons stated in para
May I just complete?
hereinafter.
Now, please come to
So,
8.
please, no, my lords, there is a
Read the whole
discussion.
thing, read
Read
the
the whole
I'll
thing.
all
Fair,
read
my
it.
lords,
The compensation amount payable to the society, owner of the land, in our considered opinion, can be recovered from the occupiers of the land for the reasons stated in para 4.2 here and above. In fact, while determining the allotment price in favor of the occupiers, the state is expected to levy some additional charge for creating a surplus pool to be utilized for improving the infrastructure and basic amenities in that congested area. To be more specific, it seems to us that the state and its instrumentalities deserve to be absolved from additional financial burden to be incurred in compensating the owner on the one hand and regularizing or conferring title in favor of the occupiers on the other hand. Now, please see 8 also. The state may also explore yet another alternative for facilitating the settlement of the members of the owner society as well as the occupiers of the subject land. In this regard, the state government may identify 2 parcels of land, out of which One can be offered as an alternative site to the society for its members' residential colony. Similarly, the occupiers of the subject land can be relocated in multi-story apartments with all modern basic infrastructural facilities. This would, however, be subject to the condition of vacating the site and handing over its peaceful vacant possession to the state. But
we thought that all right, we are given, we say wishful thinking if they do it.
no, I'm only saying this, my lords. There are really two things. Let the state, my lords, reflect on this, come back to my lords with a better cut-off date, or look at an alternative. My lords can take a call on this, my lords. It can't be that they simply say 1989, you take this money and go away. It is like, my lords, rewarding encroachers. Land grabbers today, therefore, are getting away with, my lords, with a value which is less than, my lords, measly. It's a fanciful figure, my lords.
Less than 1%.
Less than 1% of the actual value. Even if I'm not getting the actual value today, it has to be a reasonable amount, my lords. Matter is festering at their instance. Before this honorable court itself, my lords, it's been pending for the last 5 years. Can it be that, my lords, I'm pegged back, my lords, to the 1989 value?
2 years back.
This is really, my lords, rewarding illegality. Let them come back on this affidavit, my lords, or at the least look at alternates and tell, my lords, what the status is.
My lords, they entered into a
No,
settlement.
with
the
great respect, my lords,
encroachers.
that was
They
3%
entered
who got it
into
never.
a-
High Court has
a
discussed this
settlement
also, it was never acted upon.
Encroachers.
And the state aided, my
less
lords, all
than
this
5% of what
activities.
we are offering.
Very surprising, my lords. This very argument shows that the state is
We
therefore
don't bear
helping
any
them.
role in this.
they had all the role to play in this, my lords.
Today, my lords, if
So,
in
can I request this, my lords? Therefore, I'm requesting this, my lords. Let them respond to our affidavit, my lords, and place submissions on why alternate land cannot be possible. Then we'll make our submissions on this, my lords. Otherwise, the option what my lords are pointing out at the end of the day, after they respond, can always be considered, my lord. That's my reference to submission.
alternate land is not possible, my lord. That part of town,
Every
we
day
have
they are
no
auctioning,
alternate. That part of town, we have no alternate
I have
land
given an
to offer them.
annexure last week or 15 days back, my lords, lands which they have sold
It's
at
like-
3 lakhs per
It's
square
like
yard.
today asking for alternate land proximate to golf links, my lords. It's not
Because
possible.
for alternate land, they first time approached the High Court in 2006. The society's writ petition is filed in 2006. Grant them compensation as on 1st January 2006. Because as far as you are concerned, we have permitted you to recover. Because at least 2006, they are agitating in court.
My lords, we will then have to take instructions on whether the state can afford this, my lords. Because I have no,
Yes,
can
yes,
we,
collect-
No state will have.
No, my lord, your lordships were kind enough to say that you collect it from them. My lord, we will just put it to them, my lord, 2006.
We have already mentioned in the order.
Just
That's right. My lords have mentioned that.
Say in perpetual compliance of the order dated 27th March 2025 passed by this court.
my lord, 97, they came to the High Court for the first time, my lord.
my lords,
97.
97 is the
Decided
first
in
writ.
2006.
No, my
Earlier
lords,
they disposed of.
1997 is the first writ seeking directions that no patta certificate
That's
be
it.
issued to
Ultimately,
encroach.
their claim, which crystallized into a judgment in their favor, was raised in 2006.
In 2021 is the date the High Court.
In perpetual compliance of the Petition Corporation has offered compensation to the respondent society land under encroachment from as on
Which one, my lord? The state has offered as of 1989.
as of in the year 1989, along with 1%.
12%.
12%.
12% interest, my lords.
Interest.
From
400 per square yard plus interest, which comes to about roughly 2,500.
2006-35.27. 2635.27 per square yard.
As on 15th September, as on 15th September 1989, at the rate of rupees 500 per square yard, along with 12% interest per annum. 12% interest. The respondent society has filed objections claiming that the compensation ought to be paid in accordance with provisions of the Right to Fair Sewage Act 2013 and or an alternate site be allotted as per the observation made by this court in para 8 of the order dated 27th March 2025. Next paragraph. On the other hand, Dr. Menka Guruswamy, Senior Counsel, as well as Learned Advocate General for the state of Telangana, were presenting court state that there is no alternative, there is no land available.
There are, please show them. Okay.
There is no alternative land available which can be offered to the respondent society.
I had 48 acres.
Next paragraph. It seems to us that the matter can be resolved by offering the compensation to the respondent society on the basis of cutoff date of 1/1/2006, namely the year in which the writ petition, which culminated into impugned final judgment, was filed by the society. Since we have already permitted the state through para 6 of our order dated 27th March 2025, to recover the compensation amount from the occupiers who have been held to be of sound economic background as per para 4 of the same order, let Advocate General have the instructions from let the state government stroke municipal corporation revisit the whole issue and in consultation with the occupiers of the land. Post this one so date for further consideration.
Could be recorded, my lords, because there are specifically lands there. We have placed material, my lords.
Mr. Guru,
Cherry pick lands to give.
They are not cherry picking. They
You
have
cannot
lands.
cherry
with
pick
question,
land
but
like
that's one.
this.
Second, my lords, on the
Policy
cutoff-
issue.
for a
you
minute.
know,
What's his
maybe
time?
it's- But they cannot.
My
cherry
friend
pick
would bear
land,
me out
my
for a
lords,
minute now.
Because
On the cutoff
this
date,
goes beyond
Not
the
just-
pale, my lords.
my friend would bear me out for a minute now.
My lords, they cannot
Feel back.
now cherry pick what lands.
Lot
my
of
lords,
time.
we can't direct them to.
No, therefore, one is alternate land, second is, my lords, on the cutoff date. My lords had indicated 1/1/2000.
1/1/2006.
That, no, the corporation has given 4 options. Why don't they answer on the other 3 options, my lords? The corporation itself has given 3 other options.
they have-
On 14/7/25, their draft policy refers to that. So let them apply their mind and come back to my lords on that also, my lords, where the dates are slightly different. Because 2006 again will be very.
Lords, kindly give us 4 weeks, my lord, we'll come back.
We'll come back.
4 weeks is.
Therefore, the cutoff date, let it be kept open, I'm saying. Let it be kept open is all I'm requesting.
Lords, we will
Let
be
it not be frozen on, my lords, 2006. Let them come back with an open date. That's all I'm requesting.
Reasonably
My
good.
lords, 2006.
No, my lords, I'll
we'll
tell
come
you
back on
what
that.
the problem is. All this, my lord, all these lands saw a spurt, as it were, in the valuation post 2008-10. Now, I am only requesting, let it be kept open, my lords. They are themselves looking at 3 other options. Why should they not look at them and tell, my lords, why they are not?
The other way out is we send the case back to the High Court in light of and consider the respective claims in terms of order dated our 25th July.
I understand. Let them come. I'm only requesting that it should be kept open. The date, cutoff date could be kept open, my lords. That's all I'm requesting.
The High Court decide the cutoff date.
Yes.
It reminds it.
That's what he is indicating.
Let the High Court decide. I don't mind, we'll go back.
So the controversy, say leave granted.
No.
The issue involved in this batch of cases is to determine competitive claims of 1I, the respondent Kalyan Nagar Cooperative Housing Society, who is the owner of the land. 2I, the liability of the Hyderabad Municipal Corporation. 2I, the liability of the state to pay compensation to Respondent 1 society in accordance with provisions of the Right to Fair Sewage Act 2013. And 3, whether any liability can be passed on to persons who have encroached upon the subject land. Next paragraph. It is broadly not in dispute that the respondent society purchased 38 acres, more than 38 acres land in Yusuf Huda village in the year 1964. Its layout plan to develop as a residential area was approved by the Upland Municipal Corporation on 16/4/1977. Next paragraph. Meanwhile, the land was encroached upon by slum dwellers, and as per the complaint filed by Respondent Number 1 Society in the year 1989, there were 503 slum dwellers who had illegally occupied and grabbed the subject land. Thereafter, from a multiple rounds of litigation between the parties, led to passing of various orders, which are not necessary to be referred to, which need not be referred to by this court, in light of the nature of order we propose to pass. Next paragraph. Eventually, after exhausting some other alternates, the first respondent society approached the High Court through a writ petition filed in the year 2006. That batch of writ petitions has been decided by the High Court via impugned judgment dated 2nd June 2021, holding that the first respondent in bracket society is entitled to be paid compensation by the state as per provisions of the 2013 Act. Next paragraph. The aggrieved Hyderabad Municipal Corporation, state has also filed
Yes.
Yes, ma'am.
as well as state of, but then reverse, state of Telangana as well as the Hyderabad Municipal Corporation are before us in appeal. Next paragraph. The matter was heard at considerable length on 25th March 2020, on 27th March 2025, when the following order was passed. Next paragraph. Eventually, in perpetual compliance with the above stated order, the appellants have offered compensation to the respondent society as on the cutoff date of 15th September 1989, at the rate of ₹400 per square yard, along with 12%
Interest, yes.
annual interest. Next paragraph. On the other hand,
Amounts to 260.
the society has reiterated its claim for compensation as per the 2013 Act. The society has also highlighted the alternates referred to by this court in para 8 of the order dated 27th March 25. So reliance is also placed on some proposals given by the appellant corporation to the state government. Next paragraph. It seems to us that the High Court will be better equipped to resolve the factual issues that are emanating from the rival claims between the parties. We are not sure whether any alternative land is readily available where the society can be accommodated and or the slum dwellers can be shifted somewhere else. It is always ideally these issues should be resolved by the jurisdictional High Court, who shall have a better assistance from the local staff and beside its own understanding of the issue. At the same time, it seems to us that the guidelines or broad criteria referred to by this court in the order dated 27th March 25 can be the yardstick for the purpose of can be a yardstick that may be duly considered by the High Court for a better resolution of the controversy. Next, for the reasons prostrated, we allow these appeals in part, set aside the influence judgment of the High Court and remit the case, set aside the influence judgment and remit the case to the High Court for redetermination of the entire controversy, preferably in light of the interim order dated 27th March 2025. It goes without saying that the said order shall not be taken as binding in nature. And if the High Court finds that there is some better or new alternatives which can be evolved, which can be resorted to, it shall have a free hand for to have such a recourse and resolve the controversy. Yes. Resolve the controversy. However, the broad principles mentioned in our order dated 27th March 25 may be followed if there is no other better alternative available.
Yes. Just one request.
We have not expressed any opinion on Friday. Parties are directed to appear before the court on so date.
I'm obliged. Just one request, my lord. My lords have said order is set aside. Order really on merits is upheld, my lords. Only now the alternative of compensation is
We
outside.
can't remand the case unless we set aside the order. We have
No,
said
not
part
because
part will set.
that would be clarified, my lords, that on merits, my lords are not interfering with the order. It's only on the manner of payment.
Merit we have already not held you entitled to compensation.
No, that-
Is what the High Court says.
It should be that the whole thing stands, the High Court should misconstrue it as
So, like-
being reopened.
That it will.
If my lords can indicate that.
All right, para next item. Para,
Very
item
deeply obliged. Can I only request for a time-bound order, my lords?
claim, na? To claim covers. So, I think कितने रहेंगे? No item.
So just one request, my lords. Some time-bound consideration, my lords, by the High Court.
We have said it may not be good for the High Court to say.
Expeditious.
We will give you a date to appear after 10 days.
Very good. I'm obliged.